Good morning, everyone. This morning I have the distinct pleasure of telling everyone to get to their seats. Additionally, I have the honor and privilege of introducing the moderator of our panel today, Justice Charles Kennedy. For those of you not familiar with Justice Kennedy, Charles Kennedy is a Lakeland, Florida native who received his BA from Haverford College and his law degree from Yale Law School. After practicing with Holland and Knight for a few years, he served 3 terms in the Florida House of Representatives and then 4 terms in the United States House of Representatives. Throughout his service in Congress, Justice Kennedy was a member of the House Judiciary Committee, and for 3 terms, Justice Kennedy was chairman of the House Judiciary Subcommittee on the Constitution. Upon leaving Congress, Justice Kennedy became general counsel to Governor Jeb Bush and was appointed by Governor Bush to the 2nd District Court of Appeals. And in August of 2008, Justice Kennedy was appointed to the Florida Supreme Court by Governor Charlie Crist. And he served as Chief Justice of the Florida Supreme Court from 2010 to 2012. And in March 2018, he was elected to serve as Chief Justice for the 2nd time. Ladies and gentlemen, please give me a round of applause for our moderator, Charles Kennedy.
Thank you very much. Thank you. I'm delighted to be here today, and I'm very pleased to moderate this panel, which, as you know, will present 3 perspectives on the independent state legislature doctrine, a theory about the proper understanding of state legislative power under the Elections Clause of the United States Constitution. That clause, which is found in Section 4 of Article 1, provides that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. The clause goes on to provide that the Congress may, at any time, by law, make or alter such regulations. So authority to prescribe the times, places, and manner of elections for members of Congress is textually committed in the first instance to the legislatures of the states, but Congress has superior authority and can override a legislature's action on such matters. The manner of elections for the U.S. House of Representatives includes the subject of how the congressional district lines are drawn. And that brings us to the particular case now before the U.S. Supreme Court, Muller versus Harper, in which the independent state legislature doctrine is at issue. A case presenting a controversy over the congressional district map adopted by the North Carolina General Assembly after the 2020 census. After that district map was challenged, the North Carolina Supreme Court in February of 2022 overturned a trial court decision and invalidated the General Assembly's redistricting plan as an unconstitutional partisan gerrymander under 4 provisions of the North Carolina Constitution: the free elections, equal protection, free speech, and free assembly clauses. The month after that action by the North Carolina Supreme Court, leaders in the General Assembly filed a petition for writ of certiorari in the U.S. Supreme Court, which was granted in June of 2022. The case brought forth a flood of amicus briefs, numbering just shy of 70. Arguments in the case, which consumed nearly 3 hours, were heard by the Supreme Court on December 7th, and a decision is now pending. When we were preparing for this panel, I was hoping it wouldn't come out before the panel. And it kind of steal our thunder. I was assured that, don't worry about that, that's not happening. So we're talking July. The cert petition presents this question framed by the proponents of the independent state legislature doctrine. And I'm quoting them: whether a state's judicial branch may nullify the regulations governing the manner of holding elections for senators and representatives prescribed by the legislature thereof under the Elections Clause and replace them with regulations of the state court's own devising based on vague again, this is framed by the petitioners, vague state constitutional provisions purportedly vesting the state judiciary with power to prescribe whatever rules it deems appropriate to ensure a fair or free election. The core question, thus, is whether state constitutional provisions, as interpreted by the state judiciary, can limit state legislative authority under the Elections Clause. Of course, a number of subsidiary issues swirl around the core question. Among these are the import of the fact that state legislatures are creatures of state constitutions, the significance of the historical practice of the states in addressing congressional election issues in their constitutions, and the effect under the Elections Clause of state statutes that recognize the adjudication by state courts of claims related to congressional elections. And of course, there are some Supreme Court precedents that have to be dealt with. The independent state legislature doctrine indeed presents a fascinating range of issues to which we will give our consideration today and from which our distinguished panel will address. And it's now my distinct privilege to introduce our distinguished panel. We will first hear from Ed Winger, who is a partner at Holtzman, Vogel, Barron et al., a top political practice based in Washington, D.C. Ed's practice focuses primarily on appellate litigation, critical motions practice, constitutional law, and trial practice. With over 10 years of experience, Ed has presented oral arguments before multiple federal and state appellate and trial courts. Prior to joining his firm, Ed twice represented former Attorney General Edwin Meese III as an amicus in cases pending before the Supreme Court of the United States. He also represented Florida Governor Ron DeSantis, former Secretary of State Laurel M. Lee, and the Florida House of Representatives in a variety of cases. Before returning to private practice, Ed served as Florida's Chief Deputy Solicitor General and as General Counsel to the West Virginia Attorney General. Ed began his legal career with a clerkship on the U.S. Court of Appeals for the Fifth Circuit and later clerked on the U.S. Court of Appeals for the District of Columbia Circuit. Ed participated in the filing of an amicus brief on behalf of the Republican National Committee and other Republican entities in support of the independent state legislature doctrine. Our second panelist is Daniel Nordby, a partner in the Tallahassee office of Schutz & Bowen, where he is the chair of the firm's appellate practice group. Daniel is double board certified by the Florida Bar as an expert in both appellate practice and state and federal government and administrative practice. Daniel's statewide practice focuses on high-profile, high-stakes matters of law and public policy, particularly in the areas of constitutional, appellate, and administrative law. Before joining his firm, Daniel served terms as general counsel to then-Governor Rick Scott, general counsel to the Florida House of Representatives, general counsel to Florida's Secretary of State, and general counsel to the Republican Party of Florida. He has represented the Florida House, Florida Senate, Florida Secretary of State, and other clients on redistricting matters following the past two decennial censuses. Daniel, who is filling in for University of Florida law professor Jonathan Marshfield, who very much regrets he was unable to be here today, will demonstrate his dexterity as an advocate by presenting the primary arguments of the parties opposing the independent state legislature doctrine. Our final panelist will be Professor Derek Muller, a nationally recognized scholar in the field of election law who holds the Ben V. Willey Professorship in Excellence at the University of Iowa College of Law. Professor Muller's research focuses on the role of states in the administration of federal elections, the constitutional contours of voting rights and election administration, the limits of judicial power in the domain of elections, and the Electoral College. Professor Muller has published more than 24 academic works, and his op-eds have appeared in the New York Times, the Los Angeles Times, and the Wall Street Journal. He has testified before Congress. He is a contributor to the Election Law blog, and he is a co-author of a federal courts casebook. At Iowa, Professor Muller teaches election law, federal courts, civil procedure, and evidence. In 2021, his second year teaching At Iowa, Professor Muller was selected by the students as Professor of the Year. Professor Muller will discuss the views he presented as an amicus in opposition to the independent state legislature doctrine based on the provisions of a federal statute. So, we now begin with Ed Winger. Ed?
Good morning, everyone, and thank you, Justice Kennedy, for the warm introduction and for that overview of Moore versus Harper. As Justice Kennedy mentioned, this case is about Article 1, Section 4 of the United States Constitution, which is quite unique whenever you compare it to the other provisions of the United States Constitution. Throughout the Constitution, the framers repeatedly referred to what states comprising the Union can and can't do. For example, states can't enter into treaties with foreign nations. The states must give full faith and credit to public acts, records, judicial proceedings of other states. In contrast, Article 1, Section 4 specifies which specific governmental body a state must that must take a federal act. As Justice Kennedy mentioned, the times, places, and manners of holding elections shall be prescribed in each state by the legislature thereof. So really the core question in Moore versus Harper is, what does it mean when the Constitution specifies one particular organ of state governments at the expense of others? So to recap what happened in this case, which Justice Kennedy mentioned, the state legislature in North Carolina passed its congressional districts, and the North Carolina Supreme Court decided that those were a partisan gerrymander. As most people probably remember, a couple years back, Chief Justice Roberts, in an opinion of the U.S. Supreme Court, wrote for the majority that partisan gerrymandering claims are not cognizable under the United States Constitution. The North Carolina Supreme Court disagreed under the state constitution and said, for all intents and purposes, that partisan gerrymandering is prescribed under the state's free elections clause. It basically says just that all elections shall be free. So we have the federal question up at the United States Supreme Court, and the position of the petitioners, in this case members of the North Carolina General Assembly, is that when the Congress, specifies that a particular state's organ of state government takes a certain act, that is a federal authority, that's a federal prerogative that dictates and in a lot of ways circumvents the typical state governmental process. So for that reason, they say that issues like this, lawmaking, cannot be checked by other organs of the state government. The view that we've staked as amici in this case is twofold. The first is that the Constitution means what it says, that setting the times, places, and manners of federal elections is and must remain a purely legislative act. What that means is that whenever the framers set out and made clear that the legislatures of each state are responsible for doing things like drawing congressional districts, it was underscoring that that is a legislative act that shouldn't be handled by organs of state government that are not at their core legislatures or haven't been delegated legislative authority. The second position that we staked out in our amici brief is that our democracy will not crumble away if this is the way that the Supreme Court comes out. Now, as I'm sure a lot of people have, seen in the media, seen in the papers, that people have criticized the independent state legislature theory based on the idea that if you allow state legislatures to do what they want with federal elections, chaos will ensue. Fake electors will be sent to Congress. Set aside that that's not the issue in this case because dealing with different constitutional provision. The position that we said is that you can apply the Constitution as written. It's consistent with prior precedent. It's consistent, as best as we can tell, with the way that the history of the Elections Clause came to be, and it's not going to be the harbinger of tyranny for the U.S. So starting with the text, I think that that's pretty much the most straightforward part of this entire argument. It says the times, places, and manner shall be prescribed by the states, by the legislature thereof. Legislatures don't mean courts. Legislatures don't mean executive bodies. That's not to say that states legislatures can't delegate this role to another legislative body, and that was the upshot of a case a couple years ago at the U.S. Supreme Court that authorized the use of things like independent state legislative or independent redistricting commissions, which has kind of been the rage in redistricting as time has gone on. In that sense, you still have a legislative determination about the way in which you're going to take and draw these congressional districts. When it comes to the history itself, though, that's been a bit murky, and there's been a lot of debate back and forth. I'm not going to go ahead in the short time that I have recount every sort of jot and tittle about who said what or what state constitution did what. But I want to point out one important fact, and that is that the respondents in this case rely an awful lot on what happened during the Articles of Confederation period and what also happened with the state constitutional schemes during that period, from the time of the Declaration to the formation of the Articles to eventually the Constitutional Convention. That's been a focal point when it comes to the history by the opponents of the independent state legislature theory. And the reason why I think that history is probably not as helpful as they make it out is that under the Articles of Confederation, we didn't have a Congress the way that we now conceive of it under the United States Constitution. Back then, the relationship between the states and between the federal government was state to government. And because of that, the legislatures were the ways that basically the states communicated with the federal government. Madison's plan during the Constitutional Convention was to wed the federal government, primarily the legislature and especially the House of Representatives, to the people themselves. And because of that, and because his emphasis was so much on making sure that Republican form of government ties the lawmakers at the federal level to the people who they are making laws for, whatever import there was about what was going on between vis-a-vis the states and the federal government during the Articles of Confederation days are next to irrelevant, given the fact that we had a fundamental change between one system versus the other. And then that leads to precedent. We do have a couple different cases out there, and I mentioned the Arizona independent redistricting case, where the Supreme Court, quite fractured, but still held that you can give lawmaking authority from one lawmaking body to essentially delegate it to another. And that's what happened, and that's why you see these independent state commissions popping up all over the place, Colorado and a couple of different places, that will allow essentially that legislative determination to be made. That's still, though, at its core, a legislative determination, which animates the whole purpose behind Article 1, Section 4 of the Constitution. One of the biggest issues now that we've actually had the oral argument that came up is the question of, okay, taking this to its logical conclusion, where do you draw that line? What is actually a legislature? And some of the examples that were given is, well, if the Constitution specifies that you have to, that these times, places, and manners have to be determined by a legislature, how do you handle the idea that governors have vetoes over legislation? And the answer to that, which I find myself pretty persuaded by, is to actually have presentment or bicameralism or anything else that's a procedure of passing a law. That's part and parcel of what the legislature does. That's part and parcel of the lawmaking process. That's where the role of the rest of the state government stops. And the way in which the petitioners in this case have presented that is one of procedure versus substance. Basically, the state constitution can prescribe the procedures for lawmaking. They can't prescribe the substance of what the law is going to be. In this particular case, going back to the actual facts of Moore versus Harper, you had the state presents its law. It was stricken as unconstitutional, and at the end of the day, the North Carolina Supreme Court said, you know what, you guys aren't getting this right. We as the judiciary are going to hire our own map makers and draw our own maps. I think however you slice it and however you are going to try to draw that line, what the North Carolina Supreme Court did under the guise of interpreting its own constitution was not procedural. That was, in effect, lawmaking. So those, I think, are the primary arguments for why what's been dubbed the independent state legislature theory actually is the best reading of the Constitution. It's it's in accord with what we know about early practice, and particularly the fundamentals of the move from the Articles of Confederation to the Constitution. And I think that it actually harmonizes pretty well with the precedent that's already been set. That then leads to what I've described as a parade of horribles. What happens if you have a runaway state legislature that's just going to do whatever it wants and, throw out the will of the people for a free and fair election, because there's no check that can possibly get in the way of them if we're going to create this independent state legislature. And the answer is actually in the second sentence of Article 1, Section 4. After it says the times, manners, and places shall be prescribed in each state by the legislature thereof, the Congress, the U.S. Congress, may at any time, by law, make or alter such regulations, except as to the places of choosing senators. So what that basically says is all this mischief, all this question, all this hand-wringing and pearl-clutching, the solution to that is to basically say, if the political process of one state isn't actually animating the Republican government the way that we see fit, Congress can actually go ahead and pass that law, rein them in. Also, going back to the idea that what a state government, what a state legislature is doing under these circumstances is primarily exercising a federal power granted to it by the federal Constitution. The judicial check isn't in the state judiciary, it's in the federal courts. And I know Dan has been doing this for a while, I've been doing this for a while too. Challenges to times, places, and manners of elections happen robustly in federal courts. We've both handled those cases, we've both done those. The federal courts are particularly well suited to figuring out issues of equal protection, issues of vote dilution, and other things. And because this particular role given to the state legislatures comes from the federal government, it would make sense to continue to use the federal system and apply the federal constitutional law to check any excesses or any abuses by the state government. If there's an issue with, if challenges are brought through the state government themselves, the state court system actually has the ability to, apply the federal government, apply those restrictions. So in a nutshell, if you will, that's the position that we have staken out as an amici. It's a little bit different, I think, probably a little bit watered down from what it is that the petitioners in Moore versus Harper are arguing themselves, but that I think is in line with what has been described as the independent state legislature theory, and it's, I think, the best and biggest reason why we hope and we expect the Supreme Court to rule in accord, probably sometime in May or June.
Great. Well, thank you very much, Justice Kennedy, for the introduction. It's always a pleasure to be here with friends at the Federalist Society. And of course, in the spirit of Gators helping Gators, I'm glad to substitute here for Professor Marshfield from the University of Florida. I should also say, in light of the substitution here, I'll add to the normal Federalist Society disclaimers that the views I'm expressing are not the views of the Federalist Society, not necessarily the views of my clients. Today, they may not even be my views in their entirety. But it's an interesting issue here. I think it's a great debate, and I've always appreciated the Federalist Society bringing different perspectives together on interesting and current questions. So the independent state legislature doctrine was outlined really well by Justice Kennedy in his remarks and by Ed. So I won't go through some of the text and some of what's already been covered here, but I want to talk about a few points. And my comments are drawn from the respondents' briefs in the United States Supreme Court, along with the brief that Professor Marshfield signed on to on behalf of scholars of state constitutional law in support of the respondents, and another brief that was filed by Professor Akil Amar and Steve Calabresi, also in support of the respondents. So it's made some interesting points. My remarks today I'll divide first into the administrability concerns with the independent state legislature doctrine as Ed has articulated it. And then I'll go into some of the discussion of original meaning that has come out in the respondent side briefs, and where those may raise some questions about the theory that's been advanced by the petitioners in what some are calling the strong form, and then in the I think Ed called the more watered down or the weaker form that some of the supporters on that side have outlined. So on the administrability side, I think there are some concerns that have been raised in the briefing. with a procedural, substantive line that some of the petitioner's side advocates are asserting for the independent state legislature doctrine. Under that argument, state legislatures, state courts may evaluate procedural concerns with legislation affecting the time, place, and manner of conducting congressional elections, but state courts may not address substantive challenges to state legislation under the Elections Clause. The administrability concern there is one that's common in a lot of areas of law. The line between procedural arguments and substantive arguments has a lot of gray area in the middle. State constitutions, for example, in many states, including Florida, require legislation to address a single subject and matter connected therewith. So is a state constitutional challenge based on a single subject violation, does that address the substance of the legislation, or does that address the procedure by which it was adopted? Certainly it affects, as a matter of practice in the legislative process, how a bill can be constructed. It prevents log rolling of unrelated subjects. So how the bill moves through the chambers is affected by a single subject provision. But a court examining it has to look at the substance of what the legislation has in it to determine whether or not the single subject challenge has been proven. Some state constitutions require amendments to legislation through the process to be germane to the original bill that was filed. Does a challenge based on germanity under those state constitutions address procedure, or does it address substance? Legislation that is adopted in a special session of a legislative body in Florida and in some states can't exceed the call of the session. Challenge based on that, procedural, or is it substantive? And finally, well, not finally, two more. A separation of powers provision of a state constitution, something that I think probably everyone in this room recognizes as an important provision of a state constitution. If a state law is challenged on state constitutional separation of powers grounds, can a state court adjudicate that? Or would that be determined to be a substantive challenge that a state court could not address, and a purported violation of the state's separation of powers go unaddressed by the courts because of the Federal Elections Clause? The final one that I'll mention is one that Ed mentioned that I think is of an obvious issue with the strongest form of the independent state legislature doctrine, which is, what do you do about gubernatorial vetoes? My kids learning about Florida state government and the Capitol, and every educated adult knows what the legislature is. It's that body that has a House and a Senate. In Tallahassee, if you ask someone where the legislature meets, they're going to say it's on the fourth floor of that funny-shaped building downtown. It's not in the rectangle building, 2 blocks to the west. It's not in the nice building with the dome and the columns where Justice Kennedy works between those two. The legislature, everyone knows what the legislature is, but how does the governor's power fit into that? In Florida, of course, as in many other states, legislation does not become law without gubernatorial signature or passage by a supermajority vote over a gubernatorial veto. So if prescribed by the legislature thereof is given a strict and narrow meaning textually, why does the governor have any role in the passage of congressional election time, place, and manner restrictions? Setting to one side the historical practice since the framing of governors routinely signing elections bills into law that address the time, place, and manner of holding congressional elections. So the distinction between procedural and substantive challenges is, I think, an administrability challenge to the strongest form of the independent state legislature doctrine. Another one is a line that some of the petitioner side advocates have argued is a line between specific and general provisions of state constitutions. So the argument is that state constitutional provisions that are very general can't be adjudicated by state courts under the Elections Clause. In North Carolina, there is a constitutional provision requiring free and fair elections that Justice Kennedy mentioned in his introductory remarks. I admit that's pretty general for a state court to say whether it is particular piece of legislation is consistent with the idea of a fair election is either going to be something that most courts would evaluate with a significant degree of deference as to what fair means or not. But other provisions in other states require election laws to be uniform or districts to be compact in the context of redistricting. Are those specific constitutional provisions sufficient for state courts to address them, or are they too general? Well, there are a lot of constitutional provisions that are framed in very general terms. Many election law challenges are brought under the First Amendment and the 14th Amendment. Notions of due process and equal protection are not very specific concepts. They've been given meaning over the years in a lot of precedent. So a line between specific state constitutional provisions and general state constitutional provisions in terms of whether the Elections Clause would bar their adjudication seems like it could be problematic from an administrability standpoint, setting aside perhaps the federalism issues with federal judges looking into state constitutions with which they may not have a lot of familiarity and deciding whether, in the context of that state's history and constitution, a particular provision should be on the general side of the line or on the specific side of the line. So I want to say a few things about the original meaning arguments by the opponents of the independent state legislature doctrine. The argument is essentially that legislature, in the context of the Elections Clause, means the lawmaking institutions of the state as they exist within their own constitutional contexts. So, absent a state constitution establishing a legislature in the state, there is no such thing as a state legislature. It exists as a creature of the state constitution, and it's reasonable, therefore, the argument goes, that it would be subject to the constraints of that state constitution in the exercise of its duties. That argument is consistent with the way that the term legislature was used in the Articles of Confederation. As Ed mentioned, some of the respondent side arguments address the Articles of Confederation, and they required congressional selection to the Continental Congress of delegates. They refer to that as a matter for the legislatures of the various states. Well, if the legislatures meant something under the Articles of Confederation, the same term legislature could reasonably, as a historical matter, be considered to mean the same thing just a couple of years later when that same term was used in the Elections Clause. And under the Articles themselves, between 1776 and 1788, states that sent delegates to the Continental Congress had state constitutions that included provisions on the selection of delegates to the Continental Congress. So at the time, contemporaneous historical practice, which I think most good textualists would consider to be something relevant in attempting to determine original public meaning, showed that the uncontested practice under the Articles included state constitutional provisions prescribing how delegates were to be selected to the Continental Congress. The good principle of originalism that text can't be divorced from context, that Justice Kennedy and his colleagues reiterated in the Connaught versus United States decision late last year, is, I think, applicable here according to the arguments of this particular theory here, that you can't take the word legislature outside of the context in which it was used in the federal Constitution, outside of the context of historical practice at the time that provision was ratified by the states. So if the Articles allowed states in their constitutions to have provisions directing delegate selection to Congress, the same sort of constitutional provisions under the current federal Constitution should be allowed now. And the states of Delaware, Georgia, North Carolina, Pennsylvania, Virginia, and New York between 1776 and 1777 all had state constitutional provisions addressing how delegates to the federal Congress should be adopted. Post-ratification history was consistent with that as well. You could look at something as general as the 10th Amendment. The power is not prohibited to the states or reserved to the states respectively or to the people. That seems to provide some play in the joints for state constitutions to reserve the power of how it should be done. You could look at the dissent of Justice Thomas in U.S. Term Limits versus Thornton, the term limits case. He dissented and noted a reluctance to read federal constitutional provisions to preclude state power by negative implication. So for anyone in the room that thinks maybe Justice Thomas got it right in the term limits case, I think that has some bearing on this as well. Alexander Hamilton in Federalist 82 also disclaimed the abrogation of state power by implication rather than by express provisions of the Constitution. New states admitted to the Union post-ratification also had state constitutional provisions that were routinely applied in a manner that affected congressional elections. Indiana in 1816, Michigan in their Constitution of 1835, the Arkansas Constitution of 1836, and this was essentially an uncontested practice for many, many years. Couple of final remarks here, going back to the framing era and how legislatures were conducted. Florida, of course, has a state legislature that's roughly similar in its outlines to the federal Congress, a House of Representatives and a state Senate that pass things bicamerally and present to the governor for signature. But at the framing, states had a variety of different ways that they conducted their legislative processes that are frankly very strange to me as someone who's practiced in Florida for my whole career. New York in 1789 required bills regulating federal elections to go to a council of revision that included the governor and various state court judges, and they would have essentially a power to pass or to veto. So at the time of the framing, there is historical practice of involving state constitutional bodies outside of a House and Senate in the lawmaking process. And that's inconsistent with the theory that legislature always means House, Senate, maybe governor, but no one else other than that. The founding era constitutions also in some of the colonies and the states vested judicial duties. Some of them did in the upper legislative chambers, similar to the British House of Lords. So there were what we would call a state senate in some states. I believe Massachusetts is one of them, that where they exercised judicial duties. It's inconsistent with the sort of strict separation of powers that we have in Florida today. It's inconsistent with the way the federal government is set up. But states at the time of the founding had a lot of different ways of doing something. The opponents of the independent state legislature doctrine would say that it's not up to the federal constitution, and the federal constitution does not mandate that states set up their state practices in a particular way. Those issues should be decided by state court judges, state court justices who have more familiarity with the context and the circumstances of their own state constitutions rather than a one-size-fits-all federal model. Thank you.
Well, thank you. It's a privilege to be here. A beautiful facility, wonderful conference. Although I will say, coming from Iowa, if the first weekend in February, attorneys from Florida are thinking about having a conference next year, I think the Marriott outside Des Moines might have more popular turnout than anything down here, but we'll see. So I kind of offer a third way in this case, which I'll sort of get to later in the remarks because I don't know that the Supreme Court's interested in it. But I find this a very hard question in terms of what the Constitution provides and the Supreme Court's questions and the way it's addressed this issue in the past. So sort of boiling this down, because again, there's lots of rabbit holes we can go down thinking about all the myriad ways to think about election administration, all the questions. At its core, I think about this as, can state courts interpreting state constitutions limit the state legislature when the legislature is regulating federal elections? So we're going to have to check through those series of boxes to really drill down to what's happening in this particular case. And the notion in North Carolina that the North Carolina state court, interpreting the North Carolina Constitution, inappropriately checked the state legislature when it drew congressional maps after the 2020 census. So in the Constitution, the legislature thereof clause, right there in the elections clause, is the legislature of the state is the one that's supposed to do it. The framers didn't use the word state. They used the word state in a lot of other places in the Constitution. But they use the word legislature here as they use in several other places in the Constitution. And as you go back through the rest of those provisions of the Constitution that use the word legislature, the court and a lot of practice has really focused on this as bringing a pretty narrow and fixed definition. It means an institution sort of defined by the state constitution, true, that has the lawmaking power and that enacts this legislation. So when the legislature is tasked with choosing senators before we enacted the 17th Amendment, it's that institutional body. No one else gets to do it. The people certainly don't get to do it. That's why we had to amend the Constitution. It was the legislature. Or when ratifying constitutional amendments under Article 5, the legislature gets to do it. And in fact, there have been instances where the question arose, can state courts construing the state constitution or other actors limit the state legislature when it comes to ratifying constitutional amendments? The Supreme Court has repeatedly said no. The Supreme Court has said, listen, I know you might have an anti-slavery or an anti-slavery provision of your state constitution, that is, that prohibits the legislature from ratifying the 13th Amendment. But so what? The legislature can ignore that provision of the state constitution and ratify a federal constitutional amendment that abolishes slavery because the Constitution gives the legislature that power. I know you usually allow the executive to veto legislation in your state, but when the legislature ratifies a constitutional amendment under Article 5, doesn't go through the gubernatorial veto. The United States Supreme Court says governor doesn't get to veto it. So legislature means legislature. It's one body. It's unchecked by anything else in the state. That's a really powerful thread through all these other cases. Well, then we have this provision of the Constitution that also uses the word legislature. And the Supreme Court hasn't said that. And in fact, a lot of the briefing on the petitioner's side doesn't say that, because you have cases where the courts have said, well, of course, the governor can veto legislation when it comes to regulating federal elections. That's your ordinary lawmaking process. And we don't think of the executive as the legislature. The executive might be engaged in a lawmaking function. That's how the framers kind of conceptualized the veto. It's a kind of lawmaking power lodged in the executive. But nobody mistakes the governor for being the legislature. Likewise, the people by constitutional or by initiative or by referendum could veto what happened in the legislature. The Supreme Court said that's okay. People by ballot initiative propose a new way of doing districting. Court says that's okay. So you've got like one lane of cases that all say, well, there's all this other stuff where not the institutional legislature is regulating federal elections, and that's okay. Whereas you've got another lane of cases that say, well, everywhere else in the Constitution, which says legislature means legislature, and really nobody else can interfere with it. This is a very hard way of addressing sort of how to handle this precedent in the case. And in fact, there's a sort of substantive procedural divide that Ed was mentioning earlier. And Justice Barrett at one point in the oral argument said, so is this an argument based in principle, or is it an argument based in necessity based on our 100 years of precedent? Because it's a tricky one to figure out, right? What that actually means in this case. So we can think about this, and I think one of the things that really got to the Supreme Court, why the Supreme Court was particularly attracted to this case, is what happened specifically in North Carolina. There are lots of times where state courts might be interpreting the state constitution to check what the state legislature does regulating federal elections. And by the way, I'm glad Ed mentioned that we don't really have to worry about that parade of horribles. We do have checks in place. Another thing I would add is right now it's seen as sort of a left-right issue, Republican-Democratic issue. There's really not necessarily that partisan valence either. In Delaware, for instance, the Delaware legislature tried to dramatically expand absentee voting this past year. And the Delaware Supreme Court unanimously said, no, you can't do that. That's beyond the scope of your authority under the Constitution, under the state Constitution. So I think there are cases in the future that, to the extent the case comes down in a way sympathetic to the legislature's position, could have sort of untold consequences for the right or the left in a series of cases down the line. But when we're talking about sort of this issue in North Carolina, right, the North Carolina State Supreme Court had recently found that partisan gerrymandering claims, much like the federal courts had found, are really kind of messy and non-justiciable, that they're not sure there are standards they can come up with. There have been these provisions in the state constitution for over 200 years that had never been construed to prohibit partisan gerrymandering, as great a plague as it was upon the state of North Carolina. About half of all the great election law cases involving redistricting in the last 30 years have been out of the state of North Carolina. This is not a new problem. And yet, a couple of years ago, the North Carolina Supreme Court construes not just one provision of the Constitution, but 4 separate provisions of the Constitution, only one of which mentions elections. And through what one might describe as as penumbras formed by emanations of these 4 provisions of the Constitution, said, well, there's our anti-gerrymandering provision, and prohibited the state legislature from enacting the map that it so wanted. So when this comes up, I mean, this is a strange thing from the North Carolina Supreme Court if you're looking at sort of what it's typically done, how sort of the interpretation of constitutional law sort of ordinarily takes place, and sort of really offends the United States Supreme Court in that case. So what do you do? Well, one is, I mean, the federal courts could do nothing and just let the states sort it out. And to be frank, this might actually be what's going to happen. Yesterday, the North Carolina Supreme Court said we're going to grant rehearing in our partisan gerrymandering case. Now, that might have been driven in part by the fact that there was an election in North Carolina in 2022, and some justices on the Supreme Court are no longer in the positions they once held. And now the North Carolina Supreme Court is reconsidering a rehearing of its own decision within a matter of months, which is an exceptional thing, and 2 justices dissented from this decision to have rehearing. But one is that the state courts can just sort of sort it out and figure it out themselves. So that is a path that's maybe going to happen in the very near future in North Carolina. Another is, well, maybe there's a place for the federal courts to step in some respects. So one might be this sort of legislative approach. Another is an approach, and it's the approach the Supreme Court probably will not take, but I'll mention it anyway, before I get to sort of the bigger one about where the Supreme Court might go. The one I suggested is, well, look, there is this provision of this federal Constitution that says legislature comes up with the rules, but Congress could alter or regulate those rules anytime it wants. Congress in the 1960s passed a statute, 2 U.S.C. 2A, which says, well, when you're drawing districts, draw single-member districts by law. And this is sort of a provision that comes out of the Baker versus Carr and Reynolds versus Sims and one-person, one-vote cases, but sort of guidance from the federal Congress. And that provision by law in 2003, Justice Scalia wrote an opinion called Branch versus Smith that says by law includes state courts, because sometimes the legislature doesn't get around to drawing the maps in a timely fashion, and we think Congress by law means state courts can get involved. So my modest suggestion was, given how messy I think this constitutional question is, maybe we could just look at the statute where Congress has used the words by law, where Justice Scalia himself says by law includes the state courts, and as a matter of statutory precedent, we just say, well, I guess North Carolina can do this. We don't have a constitutional matter. No one seemed to bite on that at oral argument, so we'll see if anyone's interested. But the other thing that the federal courts have done in rare cases, and the reason sort of this case comes up where it is, really traces back to Bush versus Gore. So in 2000, despite the fact that there was sort of the 5-4 decision that comes out of the United States Supreme Court reversing the Florida Supreme Court's decision on equal protection grounds, 3 justices wrote separately, led by Chief Justice Rehnquist, to say, well, we have a different issue. Article 2 of the Constitution also uses this word legislature. The legislature directs the manner of appointing presidential electors. And in this case, the state Supreme Court interpreting state statutory law sort of deprived the state legislature of the meaning it intended when it came to a federal election, a presidential election. It's a very similar setup to what I set up at the beginning, although we're talking about a statute, not the Constitution. So it's a little bit stranger, right? If you're interpreting the statute, how much deference do you give to how state courts are construing their own state statutes? And Chief Justice Rehnquist says, well, usually we're quite deferential, but not always. If you deviate too sharply or go too far or engage in kind of absurd interpretations, federal courts can step in as a check. At oral argument in this case, there seemed to be a lot of attention from a lot of the justices around a principle like that, to say maybe sometimes you just go too far. And maybe it's okay for the state constitution, as construed by the state Supreme Court, to check the state legislature in federal elections. But sometimes the state Supreme Court goes too far. Now the question, right, this line drawing problem, what's too far? How many times did the federal court step in? But what was really telling, I think, when the respondents got up, there were 3 different, one attorney general and one solicitor general and 2 former solicitors general who all argued the case on behalf of the respondents. And all of them conceded to the United States Supreme Court, yes, you can step in sometimes and check state courts when they go too far interpreting their own state constitutions. And Justice Sotomayor at one point said, well, isn't that like a due process thing? And Neil Kochel, one of the arguing for the respondent, said, no, it's not due process. We're putting in the elections clause. We think legislature means legislature, and it might be checked in some places by state courts, but just can't go too far. So it's not clear to me, to the extent that the Supreme Court is interested in this, that it's necessarily going to go as far as the respondents want, or petitioners want to say, state courts can never check the legislature or can only check them on procedural grounds, not on substantive grounds. But maybe they're checking some other kinds of bases to say sometimes you go too far. So Justice Alito asked some questions, leading questions along the lines of, was there grounding in North Carolina precedent for this decision? Were there prior decisions of the North Carolina Supreme Court that step by step led to this conclusion, and so on? So I think the Supreme Court might be attracted to a kind of middle way, and thinking about the federal courts can at times check the most egregious acts of state courts, but it's going to have to provide some kind of guidance. And for those of you thinking about practice, looking at your own state Supreme Court's prior decisions and precedents before they lead up to what might be described as a monumental or significant decision that could affect how the legislature regulates federal elections, and potentially the way that I see this case might go in the near future, at least to the extent that this North Carolina Supreme Court doesn't render it moot by issuing some kind of decision on rehearing in the next couple of months. Thank you.
All right. Well, thank you. Now we're going to have a kind of free-ranging discussion. Ed, would you like to begin responding to what you've heard?
Yeah, absolutely. Professor Muller, I think that you're probably dead right about why it was that the U.S. Supreme Court was interested in this case in the first place. Say what you want, I think, to get a partisan gerrymandering ban out of a state constitutional statute that says all elections shall be free and fair, I think most people would think that that's a bit of a stretch. It seems like there's a little bit more of a political fight going on between the North Carolina Supreme Court and the North Carolina General Assembly that doesn't seem like it's what a state court should be doing. Listening to the oral argument, I think that there is an awful lot, and I think that it seems, with the exception of the respondents, obviously, that people do realize that something went off the rails here. And the justices are very concerned about where to draw the line, how far to go, and the biggest point, it was one that Dan made, is where to actually have some sort of administrable line going forward. The petitioners, they want to go whole hog, and they're basically saying, look, unless there is a procedural rule, what's essentially you're just checking a box in the state constitution, there's no other body that can actually do anything about the times, places, manners of elections or the drawing of districts. I have not, from listening to the oral argument, seen anyone, perhaps with the exception of Justice Gorsuch, willing to go quite that far. Although I will say that the difference between procedure and substance when it comes to drawing that line, you do have a bit of a heat problem, like where is that precise barrier? But in a lot of cases, in this one in particular, I think that you have a pretty clear answer that what the North Carolina Supreme Court did was not procedure. They basically had the judiciary substitute their own map in. It's still working. It's working its way up, and like Professor Muller said, could be mooted, but that's not checking a box. That's not the way that things should go. And I think that there is a principle here that is embodied in the times, places, and manners clause, which is essentially, are you lawmaking? Is this the actual, exercise of some sort of legislative authority? If you're making law, then that's something that a legislature or that lawmaking body should be doing. If you're going through the steps of making law, something like actually going through the gubernatorial veto process or some of the examples that Dan had gave, that does seem more procedural. And this is what courts do all the time. Everyone remembers the Erie Doctrine. There are going to be tough cases, but that doesn't mean that you still don't need to figure out, in those cases, which side of the line you fall on. So I think that when it comes to some of the administrability issues, that would be my answer, is that courts need to do what they're doing, federal courts in particular, and call those balls and strikes as the cases come up. So with some of the stuff that Dan had mentioned, things like the single subject rule, things like the germanity, those to me seem like you can work those out of federal court and say, no, if you need to make sure that there's some sort of germaneness to an amendment, yeah, that's going to involve looking into what the amendment is. But at the end of the day, what you're doing is taking the steps to pass a law. And I think that there's a way to get there that could be intellectually and legally satisfying to most people who are doing this. That'd be my answer to some of the administrability concerns. And those definitely came up. I know that Justice Kavanaugh was asking a lot about them. Justice Barrett was. I think that was her main focus. When it comes to this question of, well, isn't it true that since state legislatures are created by state constitutions, it necessarily follows that they must adhere to every single jot and tittle of the state constitution that created them? I think that argument ignores to a certain extent that what the state legislative body is doing in this case is exercising a federal power. So basically, the state legislature has been more or less seconded to do a federal job. And for that reason, it should be governed and it should be held to account to the federal constitution. I think that seems like the point that a lot of the, I guess, greater to lesser adherents are arguing are kind of missing when it comes to what it is that is actually occurring whenever you have a state legislature exercising Article 1, Section 4. And like I said, the only last question I think that Dan and I went back and forth on this a little bit is the question of what do you do with original practice? Like I said, my personal position is I don't think that you're going to get a lot of juice out of what happened to the Articles of Confederation, because you're talking about a completely different system of government. You're not talking about, representatives answering to the people in the Articles days, and you shouldn't then expect a clear connection between what the Article said the legislature was to do versus what the Constitution says the legislature was supposed to do. You're just talking about completely different systems that need to answer to different constituents in those cases. And the last point is that there were an awful lot of state constitutions during this era and post-United States Constitution ratification that did have a couple provisions in there, and those are hard to deal with if you're a proponent of the pure, I guess, extreme independent state legislature theory. There are some answers to them, which I think have been teased out in the briefs an awful lot, whether or not all elections only meant all state elections. But I think that the clearer answer is more of one of practicality. Whenever you have a provision in the state constitution that says all elections shall be by ballots, if no one disagrees with that and no one challenges it, you never have this question get answered. So again, just my personal perspective on that history, not speaking for my clients or my law firm, is that you don't have an awful lot to indicate what it was that original practice actually stands for.
So I will echo, I guess we'll be unanimous then, about the sort of things that attracted the Supreme Court to taking up the North Carolina decision in the first place. The nature of the North Carolina Supreme Court's interpretation of its state constitution, with, you accurately said, penumbras and emanations to construct a ban on partisan gerrymandering. It's an interesting thing, and in the question presented by the petitioners that Justice Kennedy read either, I think suggests that too, whether a state's judicial branch may nullify the regulations adopted by the legislature and replace them with regulations of the state court's own devising. I think most on this current United States Supreme Court would say probably the answer to that should be no. I think there's probably a similar dynamic to piggyback on something that Professor Muller said with the three justice plurality in Bush versus Gore as well. The Florida Supreme Court in Bush versus Gore taking two state statutes with, I don't have the exact text in front of me, but one essentially said that the state shall reject any county election returns that are filed after the deadline. Another statute said that the state may reject any county returns that are submitted after the deadlines, and the Florida Supreme Court said, no, what it really means is you must accept returns that are filed after the deadline. So that, that's the sort of argument that, again, at least three justices said at some point maybe a state court can go too far under an Article 2 independent state legislature type doctrine as well. Another question I think that is probably an obvious one, particularly for this crowd, is didn't the Federalist papers say anything about this dispute when they were talking about the provisions? The answer is really not. The primary debate between the Federalists and the Anti-Federalists over the Elections Clause, and in the notes that you see from Madison on this provision, seemed to be about a different question. It was the question about who sets the regulations for times, place, and manner of conducting congressional elections. Should it be the federal Congress or should it be the states? And the compromise that was reached was it should be the states in the first instance with the congressional check and the ability to alter or amend those regulations. So that's where all of the play was in the ratification debates on this issue, not on the question of which body within the state's constitutional structure is the legislature or has the authority to be in these things.
Yeah, so two quick things. One is on the history, because, again, you see very little. The Anti-Federalists were pounding the table, saying, like, if Congress has the power to regulate elections, it's going to destroy everything in this government. And so that was like an overwhelming focus about the congressional power rather than identifying who it was. But yet you see these constitutional provisions, and in my judgment, the respondents, the North Carolina Supreme Court, it's not, let's say, disingenuous. The language I've used is I think about the old child's toy, a thaumantrope, where like you spin like a bird cage on one side and a bird on the other, and you spin it enough times and it looks like the bird's in the cage, right? You sort of say, well, we have these provisions of state constitutions that regulated elections, and there was judicial review at the founding. And they're like, and there you go, like that's it, that's the founding era practice. Like, okay, where do those two things happen together? Because it's not, at my recounting, until the 1860s that you see any hint of a state Supreme Court saying, oh yeah, we can check the state legislature when it comes to political issues. And in fact, deep into the 20th century, you see versions of the political question doctrine throughout state courts. They'll say, these provisions of your state constitution, they're not enforceable by the judiciary. The redistricting provisions, the single member districts, all that stuff like has to be enforced by the legislature, and we're not going to step in. So you might have those two things, but you don't see them pop up together until the 1860s. Now, similarly, you don't see a lot of instances where anyone has to make a decision about whether or not the state legislature transgressed the Constitution until the 1860s. A lot of this happens with a lot of fights about who should be eligible to vote during the Civil War, about absentee voting and things like that. So that's sort of an interesting historical piece. The second, there is this suggestion a couple of years ago, Chief Justice Roberts' opinion, in Rucho versus Common Cause, the North Carolina case that said there's no federal standards for partisan gerrymandering under the federal Constitution. Roberts writes near the end of the opinion, well, there's lots of solutions. There's, for instance, independent commissions. There's Congress. There's state courts. It's just like, here are some things state courts have done. See Florida's Fair Districts Amendment. And in dissent, Justice Kagan is sort of saying, well, I don't understand why the state courts can engage in these decisions, but we can't. And the majority's response is like, well, we're governed by Article 3, they're governed by something else, so maybe we can think about them differently. But Justice Kagan in dissent says, well, we've got Florida that does this, we've also got Pennsylvania that does this, but the majority never mentions Pennsylvania. It's not really thrilled because Pennsylvania, like North Carolina, the judicial decision from the state Supreme Court interpreting the Free and Fair Elections Clause of the Constitution, this open-ended provision, after 200 plus years to say, here's our anti-gerrymandering provision of the state constitution. So I think there's long been some discomfort from the justices on the court about using these open-ended provisions. And again, we're thinking about the line drawing problem. Is it procedural substantive? Is it general specific? Whatever it might be. But there's no question that this case rubs them the wrong way. And the question is, do they let the one bad apple that they think sort of slide? Do they find a way of trying to make it narrow? Or do they sort of attack it a little bit more broadly and provide that sort of more substantive hook that the petitioners in this case wanted?
All right. Well, thank you all for your excellent discussion. That's very interesting. We have a few minutes for questions now. So who will be we don't want to delay lunch, however. So we will not delay lunch. So if you have a question, I think you should go to a microphone. So
promise not to delay lunch, okay?
I'm not sure I believe you.
Well, yeah, that's, I plead guilty to that, all right? My question is, somebody mentioned the Fair Districts Amendment. Is that, or amendments, which are, what do you call them, people adopt, initiatives. Are they are those inconsistent with Article 1, Section 4?
I mean, again, it depends on what the court wants to say.
Well, we always know that.
So
You
there was
never know what Justice Kennedy, was going to say.
let me just
I
say on
rest
that,
my case.
they were challenged on that basis actually right after their passage in federal court. The 11th Circuit actually issued a decision saying that they were not inconsistent with Article 1, Section 4. Said that they didn't need to get into the procedural substantive, that, you know, to the extent it mattered, they were fine. So we have an 11th Circuit decision saying that, at least under the precedent at the time, that's pre-Rucho, pre a lot of these cases, saying upholding them against an elections clause challenge.
All right, anybody else? Well, I have a question. It's kind of a technical question like I like to ask. Now, I understand that in the North Carolina Supreme Court, the majority of the court said that the elections clause issue was forfeited because it had not been raised in the trial court. Am I correct in understanding that?
I believe there was an argument about that. It certainly came up, I think, in the state respondents' briefs. I don't recall it being addressed or asked about an oral argument, though. It doesn't seem like the justices are particularly interested in that. But if I'm wrong, someone please correct me.
It was the North Carolina Supreme Court, I think, had an interesting conception of forfeiture. It was certainly raised in the trial court briefing. I don't know how much it was pursued in the trial court briefing, but I think I would not have called it something that was not raised in the trial court level.
All right, so not forfeited. Anybody else? Yes, sir.
Sure. Hello. I don't know. Is this
It's
working?
on, just speak up.
So I guess when you're looking at what the North Carolina Supreme Court did, you know, if you're a good constitutional textualist, wouldn't you look at the word fair and say, well, what does fair mean? And, you know, can't the court apply what the word fair means? Now that seems like a really wild, almost delegation of like, wow, a court's going to be deciding what's fair and then implementing that. But you could also say that's what the text says. And if the people don't like it, they can remove the provision from the Constitution. You know, are we saying there's like a major questions doctrine for constitutional interpretation, or you know, it does seem like this really broad provision, but of course, almost every provision that most people care about in the constitutions are extremely vague: due process, equal protection, freedom of speech, etc. So, what's different about this one? And if you're a true textualist looking at the word fair, why is that exempted seemingly from, you know, how we would normally apply those principles?
So I think, yeah, the equal protection due process point is a fair one that's been raised by many people to say, well, we expect the judges to be able to interpret these things. What's wrong with the Free and Fair Elections Clause? One theory posited, I think Andrew Grossman and others were on a brief on this in front of the Supreme Court, was to say free and fair elections actually refers to sort of the qualifications of eligible voters. And to the extent that we're defining the scope of the electorate, we need to ensure that a free and fair election includes a broad enfranchised base of people. And that's how we have sort of this popular sovereignty, the notion that sovereignty resides in the people, that they are the ones who enact this Constitution, enact these things. So tracing the lineage of the earliest free and fair elections clauses in many states ties to the ability to participate in the electoral process, and not as sort of a check on sort of all political rules that might be applied in the state. So I think that's one way of thinking about the originalist argument. I haven't dug deeply into the issue, but it struck me as one of the more interesting briefs that came out of this case.
All right. Well, I want to thank you all for, did you have anything else?
No, I was just going to echo what Professor Muller said, and I think that's, you know, if you take something like the Free and Fair Elections Clause and use that to create what's essentially a brand new cause of action that didn't exist before, it does sort of, I don't think I need to remind the group here, it does sort of shake up a little bit about, what you're doing actually the administration of justice and, you know, applying the law as written. It's like sort of a substantive due process-esque criticism that comes up that I think is a fair one to assert. So when it comes to those vague processes, we can figure out and we can know when, someone has treated a similarly situated person differently for purposes of an equal protection violation. If they didn't have, their day in court for purposes of a due process violation. Once you start moving on to, we're going to create a substantive rights or a substantive prohibition using one of those, it does. I mean, people can tell and judges can tell whenever you've moved past doing the work of a judge versus doing the work of a policymaker or a legislature.
Now, I would just say very briefly, because I don't want to hold up lunch either, that, however, whatever substantive standards might be put into a fair election, I think any standard of review that would require a court to evaluate whether something is quote unquote fair should be an awfully deferential standard of review by the judiciary in that context.
All right. Well, that kind of brings us to the conclusion of this panel. I want to thank all the members of the panel. Let's give them a round of applause.